Hello, everyone. This is becoming a habit. Welcome to yet another impromptu Talking Feds episode to try to analyze yet another indictment. This one against Donald Trump, but 18 other sorry souls who put their lot in with him and now are looking at RICO charges in Fulton County. We wanted to give this a quick deep dive, and we've got a perfect group to join us. The estimable and incomparable Norm Eisen, requiring no other introduction. And maybe you should know, but if not, you'll quickly be learning as this case comes to market. Gwen Fleming, who's with us, who was a former, do you go Gwen Keyes Fleming?
Gwen Keyes Fleming, yes.
Is your prefer? Thank you. Who, among other things, was the district attorney in the neighboring county to Fulton County, DeKalb County. So is the perfect person to try to give us a vantage point on where Fani Willis is coming from. Gwen, thanks so much for joining.
Thanks for having me. Glad to join you.
I wanted to start with what I think is a kind of a hard question and maybe a little professorial. So sorry if I'm hitting you with this, but man, people, RICO, it's a little confusing. Racketeering activity. We have conspiracy here under C in Georgia. Overt acts, criminal enterprise. What's your best single sentence, clearest sentence about what Donald Trump and the 18 have been charged with doing? Either of you?
I'll take a whirl, unless you want to go first, Harry or Gwen.
I'm the newbie here. You go ahead.
Literally we should work this out together. I don't think it's so straightforward. Go ahead.
Donald Trump and his co-conspirators allegedly violated multiple Georgia criminal laws as part of operating as a loosely organized theft ring. But instead of attempting to steal money or cars or fur coats that fell off the back of a truck, they were attempting to purloin the rightful electoral votes of Georgia that belonged to Joe Biden and to take them for Donald Trump, or at least away from Biden.
Let me stop you, because we're in the business of constructing a single sentence. Gwen's
that
already
was
laughing,
one sentence. That was one run.
I saw lots of semicolons and commas.
There was no period there.
100%. No, I'm saying we reached the end of that sentence, but I don't know if we really got there. I want to be a little bit more legal and track the statute, but still stay comprehensible. So I think your idea, I think this is excellent way of understanding. It's sort of, but what I take it as being is there's a metaphor here. You can think of it as a theft ring, and they're stealing the election. But let me get a little bit more.
It's no. It's more precise than that. They are attempting to take the electoral votes away from Biden and, if possible, seize them for Trump. So
that's the end. But so first, they're conspiring. Let me start here. They are conspiring to do what? It seems to me they're conspiring. So Gwen, who has prosecuted these things.
I would say they are conspiring to use lies and deception to obtain a ill-gotten second term, and in doing so violated numerous statutes in the state of Georgia.
All right. Okay, so
By
notice, by the
lying to
way,
officials, by
yeah,
intimidating witnesses, by
etc. All right, now we kind of know our stuff, I would say here, but we're flailing a little, I think, or at least we're. So let me, and I'll try to zero in. I think I'll be a little different from both. So let's see. First, they're conspiring. Conspiracy to me means they're agreeing to do something unlawful. I think the thing they're agreeing to do is violate RICO in Georgia. I think that what that means is they have established, or they're conspiring to establish a criminal enterprise. And we're defining a criminal enterprise as one that has what? An unlawful purpose and operates through a pattern of racketeering activity. And that activity here consists of at least 2 enumerated crimes under Georgia law. I'm being more nerdy, but have I said anything wrong yet? And let me ask in more particularly, the criminal enterprise aspect of this. Is that an element that the prosecutors have to show beyond a reasonable doubt? Or is that are they just sort of asserting, it's a criminal enterprise there, and we have to show beyond a reasonable doubt the 2 acts of racketeering activity that they employ. Does
So
that make sense? And then I'll get a little less nerdy here.
my recollection is that's one of the ways that the Georgia statute differs from the federal statute. You don't
Yeah.
have to prove the enterprise or the existence of the enterprise beyond a reasonable doubt. You can describe them as a loosely affiliated group that has a common purpose and committed these predicate acts in furtherance of the conspiracy in this case.
And the
So that's just
conspiracy is to violate RICO. Let me ask you this. What do you have to prove beyond a reasonable doubt here? An agreement to violate RICO, and that latter part is, since you can just assert the criminal enterprise, is it really an agreement to
and an act. Yeah, you got to have
an
the
act,
agreement.
and the violation of 2
Predicate acts under the statute.
predicate
One
acts
of
on
2 of
That's
the
the core.
43.
That is
that
the core. The quote.
Have I just stated the elements for the jury?
The core,
Maybe,
Harry,
yeah.
is you have, but the nomenclature is in Georgia, pattern of racketeering
Right.
activity. That is the core thing to focus on. That is why you need to have the predicate, the sufficient predicate crimes,
Yeah.
which is which includes federal ones as well as 40 unique Georgia statutes, many of which are alleged to have been violated here.
All right, so let's just put this in terms of one sentence, but use the word conspire because we're in C in RICO. That's what they're alleged to have done. So they are alleged to have conspired. Am I right? To violate RICO, and that's because we don't have to prove it, but they're a criminal enterprise. They're the theft ring, and they engaged in a pattern of racketeering activity, which basically means 2 of these crimes. I mean, am I right that, this goes to critics of RICO, etc., but when all is said and done, if Fani Willis can show that these guys wanted to steal the election for Trump and committed 2 of the predicate acts, she should win?
That's correct. It only takes 2.
That's the end. And I haven't missed anything, right?
No.
Yeah. Okay. All
Well,
right.
let me say this. They have to be 2 distinct but interrelated crimes. So for example, you can't have a malice murder and a felony murder based on the same death, for example. Obviously, we're not talking about a violent crime here, but you can't have 2 sides of the same coin. They have to be distinguishable crimes, which we have. We have way more than that.
Way more
Way
than
more
2,
than
right? I
2.
mean, yeah, okay. So let me ask you, Gwen, because you've done this kind of thing. It's a bit of a confusing, or you could just say capacious statute, especially in Georgia. When push comes to shove, is there a record of juries being kind of confused or pushing back on this?
No.
Or we've heard the success stories of Fani Willis, starting with the Atlanta educators. That's just, does that seem to be par for the course in Georgia?
I think so. So again, remember the RICO statute is the main statute that was used to convict the former sheriff of DeKalb County for killing his rival. And so we had John Floyd as part of the team. It was prosecuted by my predecessor, but juries understand the story. And we all know as former prosecutors, that's what we do. We tell the story, we tell how each bit of evidence fits into the story. And then during our closing argument, we don't list it act by act. We tell the story and we can encourage them to check different things off, which is what I imagine she would ultimately do, and why this is in paragraph form like this as opposed to just straight prose. Because now as she presents evidence during her case in chief or even on cross-examination, in closing, she can say, I have established these overt acts, 9 through whatever, or, moving to 100 plus whatever.
Of which I need
and the
one. Yeah.
Right, right. And so I actually think this indictment is laid out very well, given the amount of activity that's alleged. And it seems to read much easier than some of the other indictments, RICO indictments that I've seen.
All right, it's a great place to start, and I think it's always useful to think about how the other guys are going to attack it. And Norm, so your defense perspective is invaluable here, because I'll raise a sort of counterpoint. It's all laid out, but it's not such a story to me. What it is, I mean, Norm's New York Times op-ed today, which somehow he had ready to go. Don't ask me how. 45 minutes later, that's a story. It's got 4 chapters. It's 4 things they tried to do. To me, these 161 acts that are the guts of the indictment are a kind of compendium, and that's fine in terms of the indictment. But
don't confuse.
So you're disagreeing with me, Gwen. So here's my question.
Don't confuse.
Yeah. Tell me.
Don't confuse the indictment which is a technical, as you well know, you've done many more of them. I've only torn them to shreds as a defense lawyer. Other than it is fair to say that over the years, I occasionally have worked with prosecutors, been hired by the government. I prosecuted I'm one of the only ones who's seen a criminal trial through to prosecute against Trump for high crimes and misdemeanors. But with rare exceptions, I'm a defense lawyer. This document is intended to be legally sufficient to get us through the motions. It is not her opening statement. What I tried to do in the Times
so that's where I want to move
to channel the opening statement.
And to prove Norm's point, think about any other normal indictment, just a regular case. It says, on such and such date, the defendant is alleged to have committed or committed a felony, to wit, and then you list the felony in the following manner. Then you miss the charges. It does not read like a story, but is a legally sufficient document to be able to notice the defendant as to what the charges are. Similarly, this is a legally sufficient document that provides notice as to where the DA is going and potentially the evidence that she has.
100%. And I don't mean to quibble about the legal sufficiency of the indictment. It is like 160 times legally sufficient. But I'm just asking about, the important point of now having leveled these basic charges, the task of packing them together and unpacking them in a story for a jury. And I'm focused on what you said, Gwen, about how this has been successful in Georgia. So I assume if it has been, it's because people have been able to take these very broad, multiple allegations of conduct and bring them home to a jury in terms of, here's a criminal enterprise. This is a mafia-like operation that all these things kind of come together. Can you speak to that?
And so if this was my theme, and I had to come up with an opening.
Yeah.
Building off of the one sentence that we started with, you mentioned the lies, and you say the lies occurred in at least 4 different buckets. Soliciting high-level officials, including the Secretary of State, the governor, the Attorney General, members of the House and Senate. And you can mention whichever defendants you want. Talking about also influencing and intimidating witnesses in terms of poll workers and the charges that relate to that. Mention submitting false documents for the fake electors scheme and holding yourselves out to be public officials that were not actually the truth. And then finally, all of the criminal trespass to steal or alter voting data. I mean, that makes it very simple.
Yeah,
And
and
you
I mean, in a
still
word, you
cover.
get thematic, right?
Right.
And that's okay. So let me. I think what all of us have recognized as a huge contribution on her part is the holding accountable, potentially, all the president's men and women, starting with the gaggle of crackpot lawyers and plus Jenna Ellis. Let me ask it in those terms. She actually said, and Gwen and Norm, were you surprised? She contemplates trying 19 people together. Now, I know she thinks some of them, and we all think that, and Gwen, you would have experience, that people will plead out. But I mean, really, we're not going to see a trial of 19. What might we see?
So I think you're right. I think 2 things. One, as an opening statement, the night, literally within hours of receiving the indictment, you can't expect her to say anything other than, I'm ready to go, and I'm ready to go on all 19. That was pretty much the underlying message. That's what every
Okay.
prosecutor would have said. And suggesting anything else means that you don't have confidence in your case or you think that there's a problem. It gives an opening for the defense teams to attack you. So she is not the type of prosecutor to let that happen. The reality is, as this case goes on, after all of the motions, after all of the discovery is shared, she may win some motions, she may lose some motions. I hate to think of that, but most likely, defendants are going to start to really understand what are their chances at trial. And when you're looking at some of the maximum penalties for these charges, they may be more willing to take a lesser sentence on a different charge in agreement to testify against others in the indictment. And so while she said she's ready for 19, and I believe she is, I think the reality is, as this plays out over however many months, it's naturally going to whittle down to a select few that would rather take their chance in front of the jury. But I don't think all 19 will take that chance.
In the Atlanta teacher cheating scandal, in the Young Thug, the YSL RICO case, many of those charged ended up taking deals. Some of them got very sweet deals.
And
She
you know this, the earlier you come in, the better. I mean, there are 19 people thinking seriously, 18, I should say,
yeah.
thinking seriously about do we come in?
I don't,
and
but that there's a difference
yeah.
here, which is this is not the normal rules of self-preservation. There is an element in which some of these are going to lash their future to Trump. They
No matter what.
understand that
Yeah.
yes, they have drunk the Kool-Aid. It's so that's going to be a part of the calculus here. Some are going to wait and see what happens. Mark Meadows has sought to remove how much of the case is going to end up in federal court. So there's so many moving pieces. The truly ominous thing for everybody who is not Trump is once even if, unlike say in the federal cases where Nauta and De Oliveira in the Mar-a-Lago case are clearly gambling on Trump winning and pardoning them or shutting down the cases, it's not a crazy gamble. Here, there's no federal power to stop the case at all for these other defendants, so they are looking at going to trial.
And going to
And
jail.
that is gonna potentially for a long time. Mandatory minimum of 5 years for the RICO. It can be probated down, but the maximum penalty is up to 20 years. So, there's
In
some
Georgia State
very,
Penitentiary. That's some kind of hard time. Now, Trump, of course, we've always been focused on him. He may wriggle out if he becomes president, but you're
yeah.
right. The other 18 can, he may. We can talk about that, but the other 18 surely can't. So, what do you think they're thinking now, Norm? Do you you sort of been in the mindset? Um, is there gonna be, and what's the sort of timing? Because I've always thought in the federal system, I'm the prosecutor. Whoever comes to me first gets the best
Yeah,
deal.
no doubt.
Uh,
Well, she's already given a bunch of deals to
right.
these unindicted co-conspirators, 20 of them who are named throughout the document. We know a bunch of them
Oh,
are the
they're
fake
30. But
electors.
here's a good question.
30,
Who's number
pardon me.
20? Who's number 20 from December 18th? Is that Flynn? Seriously, any thoughts? So I'm being a little elliptical. December 18th meeting, which is the craziest thing ever, talking about seizing voting machines and the like. They talk about unindicted co-conspirator number 20. So we have to think about someone in that meeting who's guilty. So it's not a Pat Cipollone type. It's not a, Hirschman type, because they don't join the conspiracy. Could it be Flynn? Who could it be?
Patrick Byrne was in that meeting. I don't think he's
Oh,
cooperated.
or the pillow guy, maybe. Lindell, maybe,
Mike
huh?
Lindell for sure. It's not him, but I don't.
Uh,
We do not have sufficient
okay.
information to identify who and it could be somebody else we haven't focused on who was there. So we just don't yet have the
All
information.
right.
It took a while to untangle some of the mysteries of the Jack Smith indictment, and I don't know about the two of you, but I've been turning these pages, and every time I do, it's very rich. Every time I do, I find new stuff.
Yeah.
And, I figured out after 3 or 4 days that I think the most likely candidate for Smith's conspirator number 6, which he was the unindicted conspirator number 20, Harry, of that, was
Oh,
probably Boris
Big
Epstein. I
Boris?
went back
Yeah.
and turned the pages. So we're going to have to do that for this. And that's going to take we're now going into a period of where it's going to be constant legal news. The three of us are going to be very heavily employed
Yeah.
because it's going to be constant legal news, and not just Trump, Georgia. The other three criminal cases, the fake electors case in Michigan, possible additional state cases, all of the very important
Yeah.
civil cases, E. Jean Carroll, the New York AG. I mean, it's peak talking feds
Right.
time.
Surely true. Let's stick to Fulton County for what, because the timeline I think is a little perplexing for outsiders. So Gwen, let me ask you, on the one hand, removal, all the pretrial things, 18 defendants who can come up with all kinds of pretrial motions. On the other hand, Georgia law, I gather, dictates that any of the 19 can call for a speedy trial and have it within about 4
4 months.
months.
Mhm.
What do you see as the range of plausible schedules and timelines for this behemoth case?
Well, to be honest, I think that is the biggest unknown for me if I was planning this case, because
Yeah.
again, loving the RICO statute as I do, I would want to still be able to tell the whole story with everybody all at once. Once you start siphoning folks off, either because they are removed to federal court, which again I don't think is likely. I'll say that again for Norm. I don't think that is likely. um, but once you also start having defendants exercise their right to speedy trial, you no longer are able to tell the whole story the way you would have had everybody been sitting at the table. And I say that because I anticipate, if one chooses a speedy trial demand, they're going to file a motion in limine to prevent discussion about co-conspirators that are not sitting at the table with them. Um, so that limits or handcuffs the DA a little bit about being able to explain how all of this is interrelated.
If someone does do this, Gwen, does the judge then have discretion to sever them out, or what could the judge say if the prosecution really wants to keep them together? Fine, you've exercised your right 4 months from now, and same for everybody.
I mean, I honestly think that would be my argument as a prosecutor. If one asks for it, then let them all have it, which is, again, why she said she's ready to go.
Yeah. Man, how crazy would that be? All right, let's focus on the mystery man, Mark Meadows. Mystery man Mark Meadows, who did move today to remove. Something, Norm, you've thought about this a lot, as have I. When the January 6th indictment didn't name him, and even as a co-conspirator, and refer to him, it seemed like George Terwilliger, his lawyer, had been a miracle worker, somehow having him cooperate without even having to plead to a lesser charge. So we didn't know, but that certainly seemed a plausible possibility on the surface. But now he's charged and facing, serious consequences in Georgia, given how guilty it seems to me he's maybe only Giuliani is as up to his, neck or above as Meadows for these various crimes. And now he's been indicted. What do you think is sort of going on with him and the federal indictment? And, is he possibly just talking in federal court, before a federal grand jury, and still having, vulnerability to charges in Georgia? And is Terwilliger no longer the magician, but the magician's nephew? What's happening here?
That old Latin legal phrase. Our profession has these wonderful old Latin legal phrases. I'm thinking of what the fuck? I mean, it's
that's not the phrase I would use.
What the Fouquet?
El Fouquet.
Not what I would use.
I mean, it's so bizarre for me as an occasional prosecutor, but mostly a defense lawyer. Like, you don't leave your state flank exposed. I had a case where a very huge criminal antitrust case that I spent years of my life on, and my client cut a federal deal, and then he was subject to deposition in all of the plaintiff's litigation, right? Plaintiff's antitrust. Harry, you do that kind of thing, key tam, for a living now.
Yeah.
Every time we did a deposition, Fifth Amendment. Why? Risk of state exposure.
Exactly.
So I don't get what is going on. It can't be. It's like two things that don't make sense. If you read the federal charges, it can't be that he's left out of the unindicted co-conspirators except because he's a cooperator, right? They made a choice. Given what he did, he's more culpable than any of those. Who's more culpable, Mark Meadows or poor Ken Cheesebro? Yeah. Not to mention unindicted co-conspirator number 6, whoever that may be. Then you look at what's going on in state court. He's totally naked and exposed. So,
and in Trump land, you could sometimes, focus on the possibilities just as a moron lawyer. But George Terwilliger is no moron lawyer. He's a seasoned former deputy attorney general.
He's as good as they come. As good as they come. And he did a very adept job. The January 6th committee, extremely effective, but one place where Meadows gave him just enough. And remember, I was on the other side for a year dealing with the Terwilligers and the Meadowses of the world. in impeachment. And I have dealt with this for decades in my congressional practice, mix of plaintiffs and defense. He gave him just enough that he didn't compromise himself, but Garland and DOJ chose, no, we're not going to enforce the contempt resolution. I mean, it was so brilliantly done.
It was
So what
exquisite,
is
right?
going on
Yeah.
here? I will give
All
you
right.
my theory,
Oh,
and then
okay.
I'll pass. My theory is that he got some kind of a no jail plea, or like a future slap on the wrist. He's cooperating, and we'll see with the feds. It's left open, right? Kind of honor, on a gentleman and woman's agreement. And then he tried to do the same with Fani, and she's like, what are you talking about? You are not getting a no jail, nothing. You're the number 2 most culpable person after Donald Trump. And Terwilliger just walked his client. He had him plead the fifth. He was forced to testify, plead the fifth, and he walked him out. And this is the
In Fulton
result.
County, plead the fifth.
The
In
special
Fulton
grand
And
County,
jury.
yeah.
having done that, it was like, this kind of sucks, but I still don't want. It's the best I can do.
It's the best you can
Let's
do.
double back. Yeah, let's double back, Gwen, to the state folks who are, 19 names. 10 or so jumped out at all of us, but there were some strangers to many of us, starting with the head of the Georgia Republican Party. There were, as Norm points out, a lot of immunity given to state actors. Who are these guys? How serious are they, in it? What are their prospects for trying to cooperate against Team Trump and the like? Give us the sort of shape of things on the state side.
I would consider those sort of the middle tier folks, the middle tier
Mm-hmm.
fish. Like, you've obviously got the ones that have received immunity already, that led to this now middle tier of folks that were revealed yesterday. And I think they may be in the best position. We'll see, based on loyalties and other things, as to some of them agreeing to take lesser charges in exchange for testimony. I will say this, though, and I don't know that people realize this. I was very interested to see the fact that Fani weaved in the protection of Ruby Freeman and the other ordinary poll workers, because there had been some speculation that they could not be reached or protected through criminal charges as victims of crimes, that their recourse would have to be civil. And so the fact that we're getting to to me, that shows Fani's heart. That's the Fani that I know, that looks out for victims, especially those that are most harmed by some very egregious actors. So I also think that crew of defendants may also be a very prime group who didn't expect to see their names listed. Remember, the special grand jury foreperson said that there would be names that we didn't recognize. That's now ringing true. But I think that also may be a group that will might decide that it's in their best interest to make some sort of deal.
It might show her heart, but it's also like a really great story of it's a black hat, white. It's amazing what they.
Oh, absolutely. I mean,
and it goes to the top what Giuliani and stuff did to them.
Right.
But let me ask. I mean, Norm makes the point that some of these higher up folks may be lashed to Donald Trump. I assume the Georgia actors, want some kind of future in Georgia politics. It won't really be.
You can't do that if you're a convicted felon.
Well, that's right. So do they are they are the people who are going to be able to skate by the ones who have been immunized, or would you think that Willis is prepared to let some of the ones she has charged, starting with the chair of the Republican Party, get
I don't know. That one may be a tougher call because of the leadership roles. I doubt very much she will make any deals with leaders willingly. She may have to, depending on how motions and various decisions are decided, whether they're in her favor or not. But that would not be her first play.
And if
she's made them. Go ahead. Yeah.
She already, there's now discussion about whether Burt Jones is going to be added. In my view, McBurney's one wrong judgment was saying she had a conflict. I do conflicts.
Yeah.
analysis for a living, and there was no conflict in her prosecuting Burt Jones. Be that as it may, he's the sitting lieutenant governor. He was clearly one of the main state ringleaders. He's off the boards for her. David Schaefer, very bad actor, embraces election denial, former chair of the
He's the
Republican
number
Party.
one bad guy in the. He's the
He's the
Mark
number
Meadows,
one
Donald Trump
Georgia.
of Georgia.
He's the number
right?
one Georgia bad guy. Kathy
Yeah, tell us a little
Latham
bit
and-
more about him, Norm. Give us a little bit more on this guy.
Well, he's
including
really-
his connection to the, command central of the
Yeah.
campaign.
He was very, according to, the allegation is that he was a true state ringleader. We know that there was on the federal level, Trump and Eastman in Toronto, Romney, McDaniel. And then in the States, people were true believers. He was the uber true believer. Apparently, he made some very unguarded comments that are alluded to in this complaint, not super sophisticated. He's important, though, Harry and Gwen. He's important because he represents the true face, one of the true faces of the lingering danger and harm here of this ideology of we're not going to let the voters choose their politicians. The politicians are going to choose their voters. This guy embraced, and he's undefiant, and he got a standing ovation.
He's defiant. You mean? He's unrepentant.
He's defiant. He's unrepentant. That's the word I was looking for.
Okay.
He's unrepentant. He's defiant. He just got a huge celebration, standing ovation when he left the party. He's taken the grassroots of the Republican Party with him on this dangerous and, in my view, criminal ideology of not letting voters choose. And the lies that prop that up, the lies and illegalities. So the David Schaefers of the world are the greater danger. Donald Trump will come and go, and he's very likely going to end up in jail. But there's this ideology that has taken root in, 25% of our country. I mean, that is the thing. That is the deterrence effect here. That is why Fani's case is so important right now, in my view. The most important, what Jack Smith did, what he had to do, I advocated it. Narrow, focus, prosecute Trump, get it to trial, get it fast. But Fani is putting a spotlight on the danger. That's who Schaefer is. And Latham and Still, to a lesser extent, are the two remaining fake electors in this case. They're very tough to let go, but Schaefer definitely not. If Latham or Still would turn into a tour guide. Now, if I were Fani, I would have wanted Meadows, just like I think Jack Smith did, complete tour guide to the conspiracy. Who is her tour guide? How do you try this case?
In fact, Gwen, let's go a little bit more to the nuts and bolts of this, including there's going to be I wanted to actually talk for a couple minutes down the line about the judge, but there's going to be a time to set the schedule pretty soon. Jack Smith, on his very simple, I think I used the arrow versus the blunderbuss metaphor. I know. Norm has talked about Hemingway and Dickens, but his case is 4 to 6 weeks. He says, I think some of the RICO cases you've talked about have gone on like 6, 7 months. Yeah. What do you see as the actual legitimate timeline to try this sucker?
I mean, I think it's going to be that long, whether you have 12 defendants or 19 at the time. It's going to take
this
a while.
Long as in half a year.
I think so, unless one of them becomes the tour guide, in which case, you put that person on for a couple of days and walk everybody through it all, and that becomes sort of the trunk of your tree, and you just keep adding other tidbits of evidence as the branches and leaves from the other witnesses. So and again, it's hard to say how long it will take, because it really depends on how many defendants we have to go through in terms of their individual cross-examinations of each witness.
I mean, that's right. Even if it were short, even if it were just the kinds of allegations in the Smith case. Imagine the Smith case with 18 cross examinations of every single
Every
defendant.
witness.
But
Yeah.
excuse me, of every witness. But let's stick with this for a while. I mean, because Fani Willis gonna have to come forward and give the judge a realistic estimate of how long the case will take to try. And I don't think anyone is focused on the possibility that she's going to come out of the box and say, many months. Now, one related question. I believe, unlike the federal system, Trump is not required to be in the chair for the whole trial. Is that correct?
That's correct. We've tried defendants without them being there. They either absconded on bail or whatever else. So,
all right,
yes.
Harry, even on the federal side, if Trump makes a compelling case and the judge explains his rights on the record, he waives his constitutional rights. I think there may be a way to craft a solution. I haven't researched it. I have never done a criminal case. I have never done a criminal case without a defendant, except when the defendant was stepped back for acting out. So I know there is a mechanism.
Or if they're literally, in the Russia, but I haven't.
But they didn't try those. No. Right. They didn't try those cases.
Yeah,
So,
it seems a
but I don't
to
know
but
I know there must be a constitutional and a statutory basis for it. Maybe it's in the federal rules because I just don't remember it. But I did have
in the federal system. I thought it was statutory. Yeah, but it's not in Georgia. But nevertheless, let's say she says 6 months, and you're the judge, and I want to get to the judge in a second on the premise. I hope that's right. That Gwen, that you know him a little. What 6 months in the is this going to be scheduled for 2025, or will they can they say, oh, we'll start in February and go to August 2024, right, with everything else that's going on? How does this work practically?
Well, to be honest, if you look at the calendar, either a January start might be the best thing. If you start it anywhere near November, then you've got several, end of the year holidays and time off, and jurors wanting to be with their families, pre-planned vacations. So you almost it would have to be a speedy trial scenario if it started anytime in November or just in that last
I mean,
term.
Norm, how will this work? Let's say Georgia just, goes Georgia and says, okay, you asked for a speedy trial. Here you go. I don't care what other people do. I'm setting this 6-month trial for January 2024. What the fuck? How's the Latin phrase maxim?
We are in. I do not believe.
The country of what the fuck, the continent of what the fuck, yeah.
You would be in, now, Gwen, you see, I use that dirty word. I should have said, what the F? And now Harry's going to town. Harry and I have been friends for over 30
Norm
years.
Gave me permission. I take his lead. But it is my podcast, so I take responsibility.
I think that, we're in such unusual territory here. Federal judges on the federal side, is not unheard of to have 2 federal judges consult about a trial schedule. Federal
that may
and
be
state,
happening, right? Yeah.
Yeah, that may be. I don't suspect that Judge Chutkan and Cannon voluntarily sit at the lunch table together at the judicial conferences. They may be seated in the C. They may find themselves when the placards are organized alphabetically together. But that may very well be happening. I think the calculus of cases is pretty clear. One thing Trump could do if he wanted to blow matters up is try to demand the speedy trial here. But there's a great risk. There's a great risk of him doing that.
Careful what you wish for.
That he's convicted. So Trump's game is going to be a delay game. By the way, I'm sure that right now Donald Trump's lawyer, the $1 billion Drew Findling, the $1 billion lawyer, so-called, he's going to be worth a lot less when he's done failing to collect fees from Donald Trump and having to defend himself, if he does, from the kind of bar cataclysm that seems to fall upon, or criminal that seems to fall upon Trump's lawyers. Be that as it may,
making attorneys get attorneys.
Findling
Exactly.
Findling is probably very upset now because Meadows blew 30 days on the removal statute. Okay, Trump
Which
was
we'll
going
talk
to
about.
run
If we
a
have time, let's
30-day
talk about
clock.
it. Yep.
He was going to run that 30-day clock out. Now Trump still has 30 days, but Meadows is front running him. That is a good Terwilliger move. You don't want this case lingering.
Meadows does have a different removal argument from Trump, don't you agree?
No,
it's not.
No.
You think it's the same? You think if Trump?
I think
there's no scenario where Meadows wins and Trump loses.
I was a little too vehement on CNN a little while ago when Wolf Blitzer read me Terwilliger's argument that there are no Meadows crimes per se. And I excessively vigorously said, counterfeit, participating in counterfeiting electoral certificates, those are phony as $3 bills. That's not a crime per se. Being on a call where the Georgia Secretary of State is pressured, just find 11,700 votes after it's been counted, recounted, certified, and set. That's not a crime per se. So I think what's going on in this, I think the removal motion is weak. I do a lot of writing on removal. Gwen and I wrote a long piece on removal in our Brookings report. We were talking about it in our sleep bedraggled.
But you were talking about Trump. You were we're nearly out of time.
It's the same.
That's a question. I actually said the opposite, probably simultaneously, on Nicole Wallace, and she didn't like it very much. Let's have a separate conversation about that. We are almost out of time, though. Gwen, can you do you know the judge here? And we've been talking about 2024. I believe the judge is up for re-election in 2024 to, why not complicate matters a little bit more? But what do you know about the person who'll be presiding over U.S.?
Interestingly, I don't know this judge.
Okay.
Based on what I saw,
he's a newbie, right?
He's the newest judge appointed in January of this year. He's an Emory undergrad, UGA law, former prosecutor, was the Georgia Inspector General. But I believe this is his first ascension to the bench, first time managing a docket. And so now he's been doing it for 8 months. Obviously, he's watched it during all of his prosecutorial years. So it was an interest, and I yet unclear as to whether he was specifically selected because he's the one that is the newest and therefore hasn't been dealing with this or have any particular relationship.
Welcome to the bench.
Right. Or whether this really was sort of a random result from the typical wheel, quote unquote, that's used for judicial assignments. I'll be honest, I'm also actually very surprised that they did not assign a senior judge that could just focus on this and nothing else.
Yeah, exactly. And again, this guy is running for re-election. Not a pretty coalescence of details. That
I'm going to go out on a limb here and say
that
Chief Judge Earl Glanville did not intentionally go off the wheel and pick a judge who's only been sitting on the bench for such a short time. Undoubtedly they spun the wheel because who wants to say, I took that out of the assignment of a judge in this case. I'm going out on a limb. Everything I know about Georgia
and he's a Kemp
comes from Gwen.
But we're seeing this in canon. There's a couple factors here. It's not just predisposition, whatever. It's having the gravitas to run this kind of, especially for anyone who's say, listen to Rachel Maddow's latest podcast involving crazy terrorist trials. A baby judge up against 19 defendants. There's more possible bedlam afoot. All right. I'm really struck by the fundamental open questions. Meadows, maybe even how you frame the one sentence, the timing of the case, the duration, etc. that we have. I hope we can maybe reconvene as things sift out and get a little more clear, and give this, a second and third and fourth take. God knows there's enough to discuss in this huge indictment that Fani Willis has brought us. So, Norm, Gwen, thanks very much for being in this first cut. Hope there'll be a second and a third, and that's all for now. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.